Good morning. Can everyone hear me in the back? I'm Irma Russell. It's my pleasure to welcome you all here. Can you hear me? For the Browning Lecture. I want to thank the Montana Law Review for its work on this lecture series. Professor Martin Burke, who is the advisor of the Law Review, professors other professors, and in particular Professors Johnstone and King Reese, who are also helping on the Law Review and transitioning. And this is an important transition. Montana Law Review is one of our capstones. We're very proud of it. We're very proud of Martin Burke and his involvement in this publication and this advice to our leaders in his work here. I'd just like to take a moment to acknowledge Martin Burke's work for many years, and I think he's here. Martin, would you stand up? It's a special pleasure for the review and for me to welcome General William Suter. He is the 19th clerk of the U.S. Supreme Court, and Judge Browning was also the clerk of the U.S. Supreme Court. It's particularly fitting that we have this lecture in honor of Judge Browning. I also want to acknowledge someone from a colleague of ours who usually introduces the program, and that's Hillary Wandler. Hillary Wandler served as clerk to Judge Browning, and it's our tradition for her to introduce the program itself. She is recovering from surgery now, unable to perform her usual role in that way, and I'd ask you all to keep Hillary in your thoughts and prayers. With that, I will introduce Elaine Gagliardi. Professor Gagliardi will tell you about this program and how many years the Montana Law Review has been supporting this intellectual endeavor. Thank you all for coming.
Good afternoon. I have the pleasure today to say a few words about Judge Browning, who this lecture series is named after. The judge throughout his years on the bench has been very gracious and hired many of our law graduates, and many of us have had the honor of clerking for him. He is a man of great ideas, and one of his greatest ideas was the Montana Law Review. In 1940, along with his classmates, Judge Browning saw the need for us to have a law review and took the initiative to start it. And certainly, the Law Review is one of the achievements that to this day Judge Browning is most proud of. Judge Browning devoted his life to the improvement of law and the efficient and fair administration of our legal system. His career has been one of public service. He began as a lawyer with the Antitrust Division of the Department of Justice. He served as executive assistant to the Attorney General of the United States in that capacity. He was appointed, as our speaker today, as clerk of the United States Supreme Court. Judge Browning was appointed back in 1958, and in 1961, President Kennedy appointed him as a judge on the Ninth Circuit Court of Appeals, where he served as chief judge for many years, and served now for more than 50 years as a judge of the Ninth Circuit. He is the longest, which is the longest tenure of any Ninth Circuit judge. Two words describe Judge Browning: innovator and visionary. As chief judge, he was a leader among the circuits. For example, he instituted the first completely computerized docketing system way back in the early 80s. He also instituted the bankruptcy appellate panel. That was his other vision. As leader, he emphasized the importance of inclusiveness and communication, and one of his greatest accomplishments was the fact that today we still have the Ninth Circuit. It was because he saw the importance of inclusiveness and the importance of communication that we still have the Ninth Circuit and that it hasn't been divided. On a more personal note, it was my privilege to have been one of his law clerks. Judge Browning taught and still teaches by setting a great example for all of us to follow. He taught me the importance of a positive attitude. There was no obstacle that could not be overcome in Judge Browning's eyes. He taught me the importance of a smile. Whenever you walked into his office, he made you feel comfortable. He worked hard. He worked 7 days a week, and he was there before his clerks and left after his clerks. And most importantly, he taught me the importance of being fair and of resisting personal bias. So it is fitting that our Montana Law Review has named this lecture series, on behalf of Judge Browning, who is one of our most distinguished jurists. So with that, I turn it back over to Dean Russell.
It's my pleasure now to introduce one of our co-editors of the Montana Law Review, John Sullivan. And John, if you don't mind, I'll note a little bit of history here as well. And that is that John is the grandson of Dean Sullivan, another revered graduate and dean, a long-standing dean of our law school. John, it's my pleasure.
Well, thank you, Dean Russell, and thank you, Professor Gagliardi, for your introductions. I just want to thank all of you once again for being here and thank the Suters for joining us today. Just on behalf of the Montana Law Review, we're so proud to have you, and we welcome you to Montana. Now, all of you, I'm sure, have flown in and out of Missoula at one point or another, and you know how difficult it can be just because of small planes and difficult travel schedules, but I'm pretty sure there are only 2 people sitting in this room that know what it's like to be sequestered in a tornado shelter on your way out. So that's what happened with the Suters last night in Denver, and that tornado shelter happened to be the Denver airport, or the Denver airport's bathroom. So we're proud not only to have the Suters join us today because of General Suter's position as Clerk of the U.S. Supreme Court, which is a great symmetry with this lecture series because, of course, Judge Browning was the Clerk of the U.S. Supreme Court as well, but we're proud that you just made it here, so welcome. Now, I could stand up here all day and talk about Judge Suter's accomplishments and the different positions he's held and the achievements that he's gained, but I know you guys didn't come here to listen to me, so I'll try and keep this brief. General Suter went to Trinity University in San Antonio and played basketball there on a basketball scholarship. And I was told this morning that when he was a senior in college, the Trinity University beat the University of Texas in a basketball game in which General Suter played. After his undergrad, he attended Tulane University and was a member of the Tulane Law Review. In addition to being the Clerk of the U.S. Supreme Court, General Suter was previously the Judge Advocate, or the Assistant Judge Advocate General of the Army, the Chief Judge of the U.S. Army Court of Appeals, and the Commandant and Director of Academics at the JAG School. So all of that culminated with his appointment as the Clerk of the U.S. Supreme Court, which gives him a great insight into the court, which he's here with us today to share. So I just want to welcome you on behalf of the law school and on behalf of the Montana Law Review, and thank you for being here. So, General Suter, everybody.
Thank you very much, John. Are we hooked up? It keeps falling off, but we'll try to make it stay on. It's probably my fault. Thank you, John, Dean, all of you. Thank you very much for inviting Jeannie and me out here. This is our favorite part of the country. We just love it. The trip in was exciting, but the most exciting part was not the tornado warning in Denver. It was when we got off the plane here, I specifically told my assistant, the itinerary said we were going to be met by the dean and all sorts of people. I think the Law Review band was going to be there. And I told my assistant, please, it's going to be 9:30 at night. We don't need anything. We can get a taxi and get to the hotel just fine. So we got off the plane, and we're walking in, and somebody says, General Suter. Well, I thought it was one of my many fans, maybe from the Trinity game against Texas. I was the team captain. I wasn't the best player, although Jeannie says I was. But somebody said, I turn around, and who is it? It's Martin Burke. And so he's there, of course, said, I just can't let you take a taxi. Professor, thank you very much. It was a welcome sight after the tornado that we didn't see to get here. Another old friend was supposed to be here. Ed Smith is the clerk of your Supreme Court. He's the only Supreme Court clerk of a state who has to run for office. But he keeps winning and getting reelected and winning and getting reelected. But he's ably represented by Rex Rink. Where are you, Rex? Maybe you don't know him. He's the deputy clerk of your Supreme Court, a very fine administrator. And also Colonel Dan Roethlisberger. I didn't know you were coming, Dan. Put your hand up. An Army colleague from many years ago, a graduate of this school, a great soldier and a great lawyer. Dan, thank you so much for coming. They've already said something about Judge Browning. I only met him once. But he was a very famous clerk because even there only 3 years, he made great innovations from 1958 to 1961. He did the same thing out at the Ninth Circuit. He was the last clerk to hold the Bible for a president being sworn in at the rotunda at the Capitol, and that was President John F. Kennedy. He was better than some of his predecessors. One of them dropped the Bible after administering the oath to the president, and of course that made the Washington Post. The clerk no longer holds the Bible at the swearing in of a president. When Judge Browning was the clerk of the Supreme Court, as they had for many years, he ran the office based on fees taken in for filing petitions and also bar admission fees. Now, in the early days of the courts, up until the late 1800s, the old clerk paid the employees, paid all the bills, and kept what was left over for himself. He was making 3 times as much as a justice. A leading newspaper in New York said one of the great curiosities of the federal government is that next to the president, the highest paid public official is the clerk of the Supreme Court of the United States. Ah, the good old days. They changed that, and Judge Browning was finally given a finite amount of, later in the 1960s, of 61, of $20,000 a year, which equates to $150,000 now. And in the late 60s, they changed everything. Now we use appropriated funds to do everything in the clerk's office. Now, Montana is no stranger to the Supreme Court. You might recall that last term we decided a case. I think you've heard of it. I think it applies to that river we crossed just a while ago. Montana PPL, as you call it. It dealt with something I'd never heard of, but you have navigability for title under the equal footing doctrine. Not something I get up and say every morning before breakfast. A most interesting case. I'm sad to report that my court reversed your court, but it's remanded and the case is still alive, so I'm not going to say any more about what we did on that case. I got to get out of town alive. I attended a luncheon a number of years ago, and it was in Washington, and I sat at the table with the speaker. And it was the speaker at that time was a famous person. He was a Tennessee senator named Fred Thompson. You ever hear of him? Fred was just a good old country boy who sort of rose from obscurity because of a case he handled down there, and finally got into making movies. In fact, he was a fine actor in The Hunt for Red October. Remember that? He didn't need no stinking lessons. He just acted like himself and was a famous actor, stayed out there and made a lot of movies, then came back to Tennessee and became the senator, overwhelmingly being voted in several times. But anyway, we're at this luncheon, and I'm sitting at this table with him, 8 or 10 people, and somebody said to him, "Senator, you lived out there in Hollywood for a few years, and now you live in Washington. What's the difference?" Old Fred stroked his chin and he said, "You know, sometimes here in Washington, I miss the reality and sincerity of Hollywood." Former presidential speechwriter Peggy Noonan, who was a great speechwriter, she wrote a book called Simply Speaking, and she says this: "The mind is a wonderful thing. It starts working the minute you are born and never stops until you get up to say something in public." Now, don't worry about that. I know the dean has told me how long I can talk, and I have a kitchen timer, and I've set it. I'm an amateur cook. My wife's the real cook, and I've set it down for 3 hours, and I'll stop on time. We'll have some time for questions. 21 years at the Supreme Court. I've watched over 1,500 oral arguments, and the arguments are really great lawyering and also great theater. I'll say this, the lawyers, your colleagues that argue up there, including the Montana lawyers who have been there, been a few. In fact, your Attorney General has been up there to argue. He was there for the last case. I don't think he argued the River case. Very well argued. I have discovered that it's very simple. Successful appellate advocacy depends on three things: preparation, preparation, and preparation. You 1Ls can write that down. I mean it. They get up there, they can answer any question. I have a view from the side. I can watch the court, and I can watch, I sit next to Justice Sotomayor to the side a little bit, and I can watch the attorney. When attorneys ask a difficult question that he or she can't answer, they lean back. When they know the answer, they lean forward. They can't wait for that question to end because they've prepared for it, they've got the answer. Some are so good, your colleagues up there are so good, they argue cases with no notes. Not one 3x5 card, no nothing. 3Ls, I don't recommend that. Take a few notes with you. One of those is the former Solicitor General, Paul Clement. He's only now 45 years old. He was only 39 when he was the Solicitor General, a former law clerk up there to Justice Scalia, I believe in 1995, 96. He's argued 60 cases. He's arguing 7 cases this term. He argued 3 of the Affordable Care Act cases, and he stands up there with not one note and can answer any question from anybody at any time, including what page something is on in one of the many briefs. He's a very fine lawyer, and he's one to emulate if you're a young lawyer. Sometimes some very humorous things happen. One time there was a counsel arguing a case, and Justice Stevens asked him a very difficult question. And you could see that this poor fellow was struggling with the answer. And Justice Stevens wasn't smiling or anything, but I could tell he was not displeased with the poor answer being given by the counsel. When the poor fellow ended, within a nanosecond, Justice Scalia said, "Now let's go back to that question Justice Stevens asked. Could you have answered it this way?" And he gave a drop-dead eloquent answer. The poor fellow looked up and said, "That's what I meant to say." By then, he was nothing more than a poor bowl of Jell-O out there, just sort of being whipped around from one side to the other. In another case one time, the justices made a big issue of a video that was included in the record of a case. A fellow down in Georgia was speeding in his car at high rates of speed, 90, 100 miles an hour or something, at night on a 2-lane road, going through stop signs, stoplights, hitting other cars, spinning around. I mean, it was a real chase. In fact, Justice Scalia commented, he said, "That's the biggest car chase I've seen since the French Connection." Well, the attorney for the driver who was injured when the police finally tipped his car and made it turn over to stop him, to make him not take any lives or anything else, they saw it as a safety matter, and he brought a tort suit against the police. He was trying to make something out of his case, his attorney was, and he said, "Well, let me say this about the chase." He said, my client always used his turn signal." Justice Kennedy leaned over and he said, "That's like saying the strangler obeyed the no smoking sign." Tip to 3Ls. Don't try to make an axe murderer sound like Mother Teresa, okay? It just won't work. The retirements of Justice Suter and Justice Stevens meant that Justice Obama would not go down as the second president in history to serve a full term who never made one appointment to the Supreme Court. That's only happened once. What president served a full term and never made one appointment? Jimmy Carter. Which president made the most appointments to the Supreme Court? Come on, Dean, make them talk. Who? Anybody guess? George Washington. What? It's a straightforward, simple question. Come on, Law Review, pick it up a little over there. Yeah. What was the only president to serve on the Supreme Court? Taft. Where was he from? Ohio. Very good. Okay, you're back up. ABA says all right again. You know, after all those years I spent in the Army, I really didn't know what to expect at the Supreme Court. I retired one night at midnight and went there the next day dressed in the new clothes that Jeannie made me buy at Nordstrom's, and had no idea what I was supposed to do, but I was pleased to find out that the workplace there was just about like the Army was. It's a very structured environment, and it's really been an honor and a pleasure to serve there for over 21 years. I've enjoyed getting to know the justices. They're exceptionally bright, hardworking. They're also very down to earth and have a good sense of humor. Easy to work for. Only 2 that are there now were there when I arrived, Justices Scalia and Justice Kennedy. So I've worked for 16 justices on that Supreme Court. One of the significant features about the court is consistency. Everything we do is consistent. We had the same justices from 1994 to 2005. That was 11 years with the same justices. Poor Justice Breyer being the junior justice for all that time. That was the longest we had the same court in 180 years. Now, in the last 6 years, we've had 4 appointments. Chief Justice Roberts, Justices Alito, Sotomayor, and Kagan. And you might say, boy, I bet a lot of changes took place up there. Nothing really changed at all. Maybe internally some did with their, when they vote and so forth, but on the outside and for the staff, it's the same court using the same rules, same procedures. Nothing really changes, and a person like me coming out of the military, I like that. I don't like sudden, swift changes. I like changes to be planned far in advance. We each year receive about 8,000 petitions for a writ of certiorari. We have a process where they're carefully examined, every case, no matter if it's a 2-page prisoner-written pro se case. The petition is looked at carefully and reviewed, and when they meet and vote, if it's 4 votes, it's a grant. We're going to set it down for briefing and argument, but of the 8,000, we only grant about 75. Look, unless your petition has a split in the circuits, same law but different result, or between a state and a circuit, or unless it's some new federal question that's never been answered, the court, I don't think, is going to grant your case. The court is not there to decide guilt and innocence and do right in every case. We just can't do it. So the grant rate is fewer than 1%. It's kind of interesting. About 70% of our petitions that come in are criminal and habeas corpus. Only 30% are civil. Of those granted, the numbers are reversed. About 70% of the cases argued in that court are civil cases, and the other 30 are criminal and are habeas corpus. Habeas meaning collateral attack after a conviction in almost all cases. All of the justices sitting today were judges before they got there, except Justice Kagan. She was the former Solicitor General of the United States and a law school dean. She had never argued cases in courts until she became the Solicitor General. And that first year she argued 6, and she did so very ably before she was nominated by President Obama, confirmed, and came to the bench. That's different from most. As I said, all the others came from the federal circuits. Now that's a change. Back in the period of the 1950s, only about 1/3 of the Supreme Court justices had prior judicial experience. Since that time has changed, and about 2/3 of them have since that time. That's a matter of the president's wishes on who he wants to be on that court, the political process of going through the confirmations of the nominee. And I don't think there's any big game plan. A lot of literature is written on it. It's all very interesting, but I think each president has to make up his or her mind and nominate whoever they want. So prior judicial experience is not a requirement, but most of them have had it. So by saying that, they know the business of judging. And judging, I know some Supreme Court justices are here. It is a business. It's a legal business, and you got to know how to do it. You just can't reach out and take a case because it's interesting. They're all interesting. Well, some bankruptcy cases are. Speaking of that, one of the biggest crowds I've seen in a long time was this a couple of years ago. Biggest crowd I ever saw outside, not inside, only so many seats in there. The biggest crowd I ever saw was Bush versus Gore, of course, in 2000. But a few years ago, the big crowd out front with TV trucks and all this other business, the case dealt with bankruptcy and probate. Your eyes all just closed. 2 law review people woke up. There might be an article here somewhere. Why were they all there? Who? Anna Nicole Smith. Were you a professor or a student? You ought to be a professor. And she was actually there. That really says something about America. I don't know what it says, but the crowd was there. But who appoints a president by the political party really doesn't mean how that justice is going to vote or anything else. Each justice can have an ideology. We all have ideology, but it has nothing to do with politics. Unfortunately, we use political terms, conservative and liberal, in politics, and then it slides over into the legal profession, and we use it there. I say it's unfortunate, but maybe they're the right terms to use. Some justices are called conservatives and some are called liberal, but you kind of got to be careful how the media labels a justice to try to determine how they're going to vote. Let me give an example. Bear with me here. Michigan versus Bryant, just last year. Police were dispatched to a gas station, and they found a mortally wounded man there. He says, I was shot by Bryant at Bryant's home, and I drove myself here. Then he died. The police went to Bryant's home. They found incriminating evidence. And at trial, the police were allowed to testify as to what Bryant told them before he died. Now, forget the exception to the hearsay rule that you think of right there, dying declaration. The prosecution just didn't use it. They relied on an old Supreme Court case called Ohio versus Roberts, which said it's admissible if it's reliable. In other words, there's no cross-examination, right? He's dead. The witness is dead, so you can't cross-examine, but the court let it in, and the Michigan Supreme Court affirmed the conviction. In the meantime, the Supreme Court of the United States decides a famous case called Crawford versus Washington, a unanimous case where a wife told the police that her husband committed a certain crime. Came time for the trial. She refused to testify on the spousal immunity, didn't have to testify, but they went ahead and convicted him using her prior to trial statement, and the defendant there, Crawford, said, look, I was denied my Sixth Amendment right to cross-examination. Supreme Court said, that's right. You're precluded, Sixth Amendment violation. That left things unclear because the court said this applies only to testimonial statements. So was the man that died at the gas station, was it a testimonial statement or not? In the Crawford case, they said it was. The wife's statement was testimonial. So back to the Bryant case, what happened? We now have Crawford. Most people thought, well, the Crawford decision is going to mean he had a right to cross-examination. The man's dead. It's not allowable. The court held 6-2 that the statement is admissible because the primary purpose was to enable police to conduct an ongoing investigation. They said, therefore, it was not a testimonial statement. And therefore, Crawford doesn't apply. Now, and again, dying declaration exception wasn't available because it wasn't raised at trial. Note to potential prosecutors, raise everything you can, get it in the record, because once you get up on the appellate level, if it's not in the record, you're not going to talk about it. I've seen justices chastise you and say, Mr. Jones, is that in the record? And you say, well, no, well then I don't want to hear about it. I mean, literally, I'm falling apart here, literally, they won't listen to what you have to say, putting it inside my pants, if it's not in the record. It's just not there. That happened in the Affordable Care Act cases just a couple of weeks ago. So here you couldn't raise dying declarations. Now, you might say, and the press said, well, that's a pro-prosecution, very conservative result, right? The conviction was affirmed, even though Crawford is the law of the land. Who wrote the opinion? Justice Sotomayor. Where the media would say, oh, no, she's liberal. She wouldn't do something like that. Who dissented in favor of the defendant in the case? Justice Scalia. Now, of course, he wrote Crawford. But he's supposed to be a conservative. Why would he give this liberal? It's because those labels are easy to apply, but they don't stick. You know, after all, of the opinions we have every year, the decisions, between 65 and 75 these days, 40% are unanimous. They all 9 agree. I couldn't get the law review to agree on what we're going to have for lunch. I want chicken salad. I want this. I want that. They agree. Last term, I think we had 60% where it was 9-0 or 8-1. It's really rather remarkable. Usually they agree to agree or agree to disagree, and the opinion comes down. But again, 40% are unanimous. The media has sort of labeled the Rehnquist court and the Roberts court, if you can call them that, as conservative. Let me just tick off a list of results, and again, I'll admit now, I'm result-oriented here, like the media is sometimes, not the reason why the court ruled that way, but these are some results from the last 25 years or so that came out of the Supreme Court. I'll just tick off a few. The court upheld racial preferences in college admissions, struck down a Texas law making homosexual conduct between consenting adults a crime, invalidated the all-male admission policy at Virginia Military Institute, prohibited voluntary student prayer at public high school football games down in Texas, prohibited imposing the death penalty for the mentally retarded and those who commit crimes while under 18, and prohibited life without parole for juveniles except in homicide cases. Now, if you're using the terms conservative and liberal, those don't sound very conservative, do they? I guess you'd say, well, they sound more liberal. So how can the court be a conservative court if those kind of rulings come down? The answer is, this is just Bill Suter speaking. By the way, I'm not speaking for the court here, Dean, we all know that. This is just me talking, a colleague of all yours. And so I don't think the court is conservative or it's really, really liberal. Let's just look at a couple of areas of the law in recent years, and let me tell you what I think the trends are. First, freedom of speech. The Rehnquist Court and the Roberts Courts have been very active in protecting free speech. You might disagree on what free speech really is, and I won't even talk about Citizens United. It's just too much to talk about, and one of your professors is writing a very fine article. I haven't seen it yet, but I know it'll be a very fine article on it, and there's a lot written, and it's just too much to try to cram into a few minutes. But let's talk about a couple other free speech cases. Snyder versus Phelps. This is that case where the Westboro Church members protested at the funeral of a Marine who'd been killed in Iraq. If you read all the media, you would think that the protesters were right up in the face of the family. They weren't. They were 1,000 feet away. They weren't making any noise. The police had approved where they stood and what they did. When the funeral cars came up to the church, they ceased doing everything. They were making no noise. They didn't refer to this Marine, just to other soldiers who were killed. The signs were very offensive. They said things like, "The only good soldier is a dead soldier." I find that particularly offensive. I think you do too, but they were saying these things. Well, the father of the Marine who was killed and buried never saw the signs, but he saw them the next day on television. He brought a lawsuit for emotional distress, invasion of privacy, won a large judgment in the district court. The Fourth Circuit Court of Appeals down in Virginia reversed it. Came to the Supreme Court, very well argued. An emotional case, I might say. You really can take sides pretty easily emotional on this, but you can't let your heart overrule your mind when you're thinking about it. The court ruled 8-1 that the Fourth Circuit was affirmed. I'll just make it concise by quoting to you what the Chief Justice said in his majority opinion. He said, "Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and inflict great pain. We cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course, to protect even hurtful speeches on public issues to ensure that we do not stifle public debate. That choice requires that we shield the church from tort liability for its picketing." There was, again, the reaction to all this, again, was very emotional. A lot of special interest groups on both sides said it's good, they said it's bad, but whatever it is, that's the law. And special interest groups that favor free speech were particularly giving loud applause. What's curious to me is that some of those groups, some I might say, want to prohibit hate crime speech. Now the difficulty there is, what standard do you use when you say hate speech is a crime? What is your standard? It might be offensive, it might be repugnant, it might be very, very rude. But just saying something to another person, you might not want to associate with them, but can you prohibit it? I don't know. A lot of colleges have tried with their speech codes. My review of it is most of them fail when they face a court. Now here's another free speech case that was argued recently, a very interesting one, but much more difficult, just argued last February. It involves the Stolen Valor Act of 2005. It's been a crime for many years to wear a military award or take any benefit if you're not entitled to it. But it was never an offense to say, "I have the Silver Star," or "I have the Bronze Star." Just to say it was words of free speech, and I think you have a constitutional right to lie. Right? Is that right? Law review? Yeah, I think so. Under certain circumstances, there are limitations. But Congress got tired and fed up with all these people going around, especially those running for office, saying, "I won this medal, I won that medal," and so forth. So they made it a crime even to say it. Well, there's a crime, so what happened? Mr. Alvarez, by the way, I have to say this. The crime for saying that you have a Silver Star or something like that is a misdemeanor for 6 months. If you say you have the Medal of Honor, it enhances it, I think, to a year of confinement. And by the way, you hear people say, the Congressional Medal of Honor. Listen to me, there's no such thing. That's on those afternoon movies you've been watching, with John Wayne getting the Congressional Medal of Honor. I'm just sorry, there's no such thing. Title 10 of the U.S. Code authorizes the Medal of Honor, the Silver Star, the Distinguished Flying Cross, all right, but not Congressional Medal of Honor. So, but over in Title 18, when they passed the Stolen Valor Act, the writers of the legislation said they enhanced the punishment for anybody saying that they were awarded the Congressional Medal of Honor. So actually, Mr. Alvarez has a perfect out here. He says, "I said I had the Congressional Medal of Honor, but there's no such thing." He didn't raise that. Maybe nobody picked up on it. Let me say this, though. The Solicitor General of the United States is brief in this case, did catch that, and did not make that error. Some of the finest briefs written in the United States are written by the Solicitor General of the United States. They're all online. They're all free. They're not copyrighted. Dean, I didn't tell him to copy it, things like that. Read it and maybe get some tips out of it. Well, Mr. Alvarez, our featured speaker here, was running for office for the California Water District Board of Directors, and he falsely told the public that he was a retired Marine, he'd been wounded in combat, and he earned the Medal of Honor. He actually said the Congressional Medal of Honor. Actually, he never served in the military one day in his life. By the way, he also said he'd played hockey for the Detroit Red Wings. That's not a crime. He was convicted. Now, of course, this came up to the Supreme Court. It had been argued. One little footnote here. Look, I was in the Vietnam War. It was an unpopular war through the media and lots of others in the American public. Yet thousands of people run around saying and writing and wearing medals that they say they were awarded in the Vietnam War. But I've never heard one person falsely say, I was at Woodstock. They don't know what Woodstock is, Dean. It was a bunch of rowdies high on drugs up in the Northeast in a field, wallowing around in the mud. No one, did you ever hear of anybody that said that? No. But we're at Silver Star, they do it all the time. They usually did it so they'll get benefits of some kind, some VA benefits or something like that because they have this medal. I saw a report recently that in the state of Virginia, it was in the media, it must be true, there when you file your state income tax return, you can check off a block if you were awarded the Medal of Honor and you get a certain benefit. There are only 4 living recipients, this report said, in Virginia, in the Great Commonwealth. 2 years ago, 600 taxpayers checked that block. Got a lot of heroes in the Old Dominion. The Ninth Circuit, your Ninth Circuit, our Ninth Circuit, said that this was an unconstitutional constraint on free speech, and that was pretty easy to see and fairly predictable. Now, it has been argued, and when it was argued at the Supreme Court, the Solicitor General Don Verrilli made a very strong argument in favor of the statute and also arguing for showing deference to Congress, and we don't know how it's going to come out. One footnote here is, if we put all liars in prison, there'd be no bed space in prison. We'd have to build more prisons. So I just don't know how it's going to come out unless it's attached, although the court might find some military exception to the rule here. Stay tuned and we'll find out. Freedom of religion. The court has interpreted the Establishment Clause pretty strictly. I think the court has loosened up a little bit in other areas, such as support of church schools and so forth. They did that a few years ago when they upheld the school voucher case coming out of Cleveland, Ohio. Just because some of the students might go to a parochial school, the court said, that doesn't violate the Establishment Clause. Now, this term, though, we had sort of a blockbuster which surprised a lot of people. The name of Hosanna Tabor Evangelical Lutheran Church versus EEOC. I'll just call it Hosanna in the highest. This was a woman who was teaching at this church school, and she was a called teacher as opposed to just a lay teacher. So she had been taught the religious training, and she conducted some religious exercises. She became ill, couldn't teach. They hired somebody else to start the school year. In February, she came back and said, I'm ready to teach. The superintendent of the school said, no, you're not. You still have difficulties and so forth, physical, and you can't teach. She made apparently a disturbance and threatened to sue. That violated Lutheran policy, and the church decided, the congregation rescinded her call and terminated her employment. She went to the EEOC. The EEOC agreed and filed suit. The suit wound up at the Supreme Court of the United States. And the thing here is there a ministerial exception to the Americans with Disabilities Act? That's a common law restriction. The circuit court said, yeah, there is a ministerial exception, but she wasn't a minister. The Supreme Court, in a unanimous decision, again, that was just last January, said she is a minister, and these laws do not apply to church-related activities. Again, not a lot of reporting on that case, which I was kind of surprised at, but it was a unanimous decision. Again, labels, they don't work. Criminal law. I think you've seen the end of the criminal law revolution. Not sure when it started, probably in the 50s and 60s. Good or bad is not what I'm here to say. I'm saying I think it's ended. You're not finding new procedural or criminal rights for defendants in cases. The courts, the Rehnquist Court and the Roberts Court, have drawn more bright-line rules to make criminal law easier to understand by police and by lower courts, and to apply it efficiently. Let me just give 2 cases here. I'll give one. Herring versus the United States, 2009. Herring was arrested because there was an outstanding warrant listed on him. He was stopped at a traffic stop. They checked out outstanding warrant in a neighboring county. They arrest him. So far, so good. All quite lawful. Search, and what'd they find? Gun and drugs. Typical case. Shortly thereafter that, what'd they find out? Oops, the neighboring county called and said, we didn't clean our database out. That was taken care of a long time ago. There was no outstanding warrant. So there was an illegal arrest and illegal search, right? It violated the Fourth Amendment, and the lower court said so. But they also said the exclusionary rule doesn't apply because there was no wrongdoing. Look, the exclusionary rule was created by whole cloth out of the Supreme Court. Felt like they had to do something about it. Fourth Amendment says searches must be reasonable, but there's no remedy. So when did the court say, here's the remedy? What case? Weeks. Law Review. Yeah. I wasn't there, but it was 1913. Wrong. 1914. It was one of those years. It was a long time ago. Well, almost 100 years ago, the court said, we need a remedy. We just can't have police going down, breaking down doors and going in, which is what they did in the Weeks case, so we got the exclusionary rule. But here, the court said, and it's sort of an exception to the exclusionary rule, if there was no wrongdoing by the police, you're not punishing the police and teaching them a lesson. Somebody just didn't make a data entry in a database, and that's why he was arrested. So the exception to the hearsay rule kind of gets more and more and more. There's some commentators that think maybe it's time to say we don't need the exclusionary rule anymore. I know that's shocking. Some criminal law professors faint when I even say something like that, but police are better trained. They have more sanctions for police. You got Bivens suits and things like that that can go on if you do something that is truly illegal and unconstitutional. But here, it was a mistake, and what they did was they found a criminal, and the court said the exclusionary rule does not apply in this case. It was a 5-4 decision, not exactly overwhelming. Now, think about this though. England and some other civilized nations do not have the exclusionary rule. They just don't have it. They weigh the evidence in each case. So I'm not here predicting that we're going to do away with the exclusionary rule. But some people are saying little by little by little, maybe we don't need it anymore. Let me jump now to the Second Amendment, right to bear arms. We've had 2 cases in the last couple of years dealing with that. The first one came out of the District of Columbia. There the court held that the Second Amendment does guarantee you, an individual, the right to bear arms, not connected to the militia cause. Okay, case over. That applied only to the District of Columbia. A couple of years later, we had another case. The McDonald case came out of Chicago, and the question was, does that right apply to the states via the 14th Amendment, the incorporation clause? And the court said, yes, it does. Another close case, but so we now have the rule that you do have a right to bear arms. Now, that opinion clearly said there are certain restrictions that you can put on this. A state can restrict you for if you're a felon, if you're a juvenile, if you're mentally unstable. They can all these restrictions on free speech, on bearing arms. After all, are there restrictions on free speech? Sure. Perjury, impersonating an officer, lying on food products. I mean, there are a lot of restrictions on free speech, and you can put restrictions on the right to bear arms. Now, what's happened, though, is a lot of jurisdictions are fighting this by imposing ordinances, usually cities, making it more difficult for a person to bear a firearm. Again, not good or bad, but they are doing this, and that litigation on the McDonald case in Chicago is still going on and on and on, trying to refine what the court meant by that case. I saw one parallel to this that I thought was quite interesting. If the Supreme Court has said that you have a right to bear arms under the Second Amendment, an individual right, but somebody is trying to keep you from exercising that right, are they similar to those back in the 50s who stood in the schoolhouse door and wouldn't let little children come in who had their right to an education in school, in an integrated school guaranteed by Brown versus Board of Education? Now, I say that, you might be shocked, but is there a difference? If you have a constitutional right, are there different elevations of rights under the Constitution? I don't know. That's why you're lawyers and you're going to figure all this out. Right to privacy. Nope, the court is not fooling around with the right to privacy much anymore. We had a case last year, NASA versus Nelson. The federal government has always required for 50 years employees to fill out forms about security and so forth. Have you ever been arrested? Have you been convicted? So on and so forth. But after 9/11, they extended this to government contract workers. You work for somebody else, but the government has a contract. Well, some of these workers that were working for NASA objected to this and said, no, no, no. We have a constitutional right to informational privacy. Now, they just kind of made that one up. But they said we have this right, and we don't have to answer these questions. And of course, they won their case in the lower courts, and the Ninth Circuit, I might add, and said that there is such a right, the individual constitutional a constitutional right of informational privacy. When it got to the Supreme Court last year, the court assumed there is such a right. And whenever a court does that, look out, because something else is going to happen. It said we'll assume there is such a right. But it doesn't apply in this case because these questions are entirely reasonable to ask you if you've been counseled for drug use and this and that and so forth. We got to know who's working for us in the Jet Propulsion Lab, for heaven's sakes. And that's where these people worked. Now, it was an 8-0 decision. I think Justice Kagan was recused. I think pretty sure it was her, but it was a unanimous decision. Justice Scalia was kind of interesting. He concurred in the judgment, but he said, these background checks do not violate the Constitution. He said there's no such thing as a constitutional right of informational privacy, and we shouldn't assume such a thing. He was amazed that in the brief of these NASA contract employees, they talked about this right, but there was no footnote citing any particular part of the Constitution where this came from. He said, I find this refreshingly honest. If you're just going to make it up, then don't say it's in the Constitution. Just call it a constitutional right. Of course, the poor counsel that represented these people was asked that question during oral argument, and he had to come up with an answer, so what did he do? When everything else fails, pull out the old due process clause. And he pulled out the old Fifth Amendment due process clause and said, that's it, that's where I find it. And you know what he could have said? He said, this right is found in a penumbra emanating from a specific guarantee in the Bill of Rights. What case? Who said that? A professor, yeah. Griswold versus Connecticut. It's there, Griswold, still good law, but the court is not sort of creating another one. The most significant affirmative action cases you thought were decided in 2003, the Michigan University and Michigan Law School affirmative action cases. The question is using race as a factor, not the factor, in school admissions. We have another case granted. Watch out for it on the docket. Fisher versus Texas. It'll be argued next term. Down in Texas, the law is if you're in the top 10% of your high school class, you're guaranteed a seat in a state college. But this woman, who happened to be white, missed the cut, and she then said, look, I wasn't selected at another school I wanted to go to. What Texas has is a race-neutral way of selecting students, the top 10%, but then they use race for picking others in the lower, not as the factor, but as a factor. And she says the state can't have it both ways. It's going to be a very interesting case. I expect it to come up, probably be argued in October or November. Of course, you're all waiting for me to say something about separation of powers. Yep, March 26th, 27th, and 28th, we argued the Affirmative Care Act cases. They have lots of other names on it, but ACA is what most of it called it at that time. Those cases dealing with the National Health Care, Obamacare, it's called lots of other things. PPACA is another acronym for the Act. Testing the separation of powers, it was really 4 separate arguments in 3 days. They dealt with the Anti-Injunction Act, the mandate, and of course that's the old Commerce Clause, cases you study. Remember Wickard versus Filburn dealt with what? Wheat, growing wheat and eating it yourself. Court said Commerce Clause covers that because it affects commerce. Next case, big one that I thought was 1995, Lopez. The Safe Streets Act says that if you possess a gun within 1,000 feet of a school, it's a federal crime. And the Supreme Court struck down, not the whole act. They never strike down a whole act usually, it's just one portion, and said, what's federal about that? Where's the commerce? Gun didn't cross state lines and so forth. That was a real sleeper. Most people didn't see that one coming. So the cases in the last few years, it seems to be the court is examining the Commerce Clause more closely, or we're just getting more cases concerning the Commerce Clause. We've had a few others, but that's the biggest issue in the Affordable Care Act cases. 2 other issues, severability and Medicaid. One of the interesting things here is that in all these cases, in 2 of these cases, both parties agreed that the lower court was wrong. So what does the Supreme Court do in that instance? The court appoints an amicus attorney to argue the case in support of the lower court judgment, to show a respect for that court's judgment, which I think is really a good idea. The two counsel who did that were handpicked by the court. They're not paid anything, and they do it and write the briefs and do the whole thing and argue the case for nothing because they are professionals. They were asked to do a job. They did it. They did a very fine job of doing it. That means when you're a member of the bar of a court, you're not just a member, you're also an officer of the court. And if you can do it and the court asks you to do something, I think as a professional and officer, you should do it. So when those cases will come down, well, as we tell the press all the time, we expect a decision by the end of June. And I expect a decision in the Affordable Care Act cases by the end of June. So where does that put us? A few trends, a little bit about the court, where we've been and where we're going. The court isn't an institution that has an agenda where it says, all right, this term, what we're going to do, we're going to win the division and go to the finals and be the NCAA. It just doesn't work that way. We take whatever flies in from the lower courts, and that's what we have to work with. So I think it's going to be more of the same. You see affirmative action. I thought it was over with. It's back up again. The Affordable Care Act cases might spawn even more litigation. Have no idea what's going on. A lot of the media predicted by listening to the arguments, and we had pretty big crowds those days, I might add, they predicted who's going to win. That's a pretty dangerous game. In fact, your batting average is usually about 50%. You win some and you lose some. I try to predict every case I've watched in 21 years. When the argument's over, I circle on my sheet who I think is going to win. I'm right 65% one year and 72% the next year. I just can't get any lower and can't get any higher. Some are pretty obvious, but on others, you just have no idea what's really going to happen. So hard to predict by oral argument, but oral arguments are great fun and great education, and I recommend all of you come up and watch one sometime. In that regard, you're all welcome to come to the Supreme Court. I think the Dean is going to round up a bunch of graduates here in a year or so or less, I hope I'm still there, and bring them up for a swearing-in ceremony. If you have 3 years admission to your state court, you're eligible for Supreme Court admission. It's good for life, for a very modest fee. So, but any of you, if you're in Washington, I hope you call and come by and see me. So with that, I'll end, because I told the Dean I would end on time, and open it up to questions you might have. Thank you. Question right here. Yes, sir.
Before your clerkship and before the rise of the internet, citizens who wanted to look at briefs and who happened to be in Washington could go into the clerk's office and photocopy them. Could you tell us a little bit about the process of making Supreme Court records available to the public online?
Thank you. That's one of, I really was appointed to be the clerk at the right time. The revolution in automation. Now, people claim that we're behind, that we use quill pens to write things up there. In fact, when you argue a case, when you come into sit down at the front desk, arguing counsel, you get 2 quill pens that are handcrafted. They're gifts as a memento to come to the court. That's part of our tradition. It's a very nice thing you want, but we really don't use them anymore. During my time there, the internet and email and all the electronic business has come up. Today, all cases that are going to be argued, we call them merits cases, all the briefs, the petitioner, the respondent, the amicus curiae, all those briefs are online for you to see. And the Solicitor General's briefs as well. I mean, all of them are there. That was an innovation started under Chief Justice Rehnquist. I went up one day when I had things ready and asked him if we could do it. He said yes, and we're doing it. And it's at no cost. Our entire docket is on the internet. Now, not all of the documents themselves, most of them, the motions and things like that, you can just read and say, a motion to extend the time, but what do you need to read it for? So we don't put all that on there. But otherwise, the cases that are going to be argued, and those are the main ones, they're all online for you to see, and the docket's there. And the transcript of the oral argument is placed up on the internet the same day it's argued. Usually, the audio transcript is not up until Friday of that week, but for the Affordable Care Act cases, they put them up the same day, which I think was a great help to the public to see the transcript and hear the oral arguments on tape. But thank you. I didn't plant that question, but thank you. I didn't do all this. The whole court staff does all these things, but the court does it, and they're fully behind this access. Very recent. So, yeah. No, I mean, yes, one right here.
Could you speak to the role of clerks on the Supreme Court?
Yes, clerks, the clerks for the justices. They're called elbow clerks. They work at the elbow of a justice. And each justice has 4 law clerks. They stay for 1 year. Each retired justice has 1 law clerk. I find them absolutely outstanding young men and women, dedicated to what they're supposed to do. They do it. They obey the rules. They work very, very hard for very little money. Each petition that comes in has to be reviewed, memos written. They have a lot of work to do, and they love their work. It's interesting, 3 sitting justices were law clerks up there. Chief Justice Roberts, Justice Breyer, and Justice Kagan. Before that, Chief Justice Rehnquist, Justice White, and Justice Stevens. Kind of remarkable, that many justices not only got out of law school, what, 35, 40,000 a year, only 39 are ever going to clerk up there. We've only had 112 justices in the history of our country. The odds of you doing those 3, the first one you got in the bag right now, your 3 L's. The second one, clerking in our court, pretty tough competition. And then being a justice, pretty tough competition there too. So it's rather remarkable. It tells you something about their intellectual ability. Any one of them, and I've met hundreds now and worked with them, any one of them you would want on your staff as your friend, as your law partner. I'm just telling you, they are that good and that dedicated to what they do. When a new justice comes on board, there's a tradition. One law clerk, or more sometimes, will stay on for the next term to help that justice staff get going. Because once a justice joins that court, the train doesn't stop. It doesn't even slow down. You just kind of run along and jump on, because the petitions are coming in 52 weeks a year, rolling thunder. And you've got to jump in and start getting your act together and get ready to vote on them. So you really need a good staff. The justices have 2 secretaries, 1 office aide, and 4 law clerks. There's no great big staff up there of anything. Only about 425 people work at the Supreme Court, and the police force is about 150. So it's a lean staff. And as taxpayers, you should be glad about that. Yes, sir.
So I heard that the Ninth Circuit is overturned at a higher rate than any other circuit in the country. So I'm wondering if, when y'all see a case coming from the Ninth Circuit, is it, we're the adversary, or here we go again?
Yeah. I have the greatest respect for the Ninth Circuit and all the circuits. First one, it's a big circuit. You have more cases than anyone. And when you start saying who's reversed the most, if you had 10 Ninth Circuit cases up there and 5 are reversed, that's much better than the First Circuit, who had 1 case and it was reversed. So I think these numbers, a statistician would say they're statistically not relevant. What do you call it? Statistically not enough there to really play with. A lot of people like to write about it and say this and that, but you also have more of a diverse population and land, lots of things going on out west here. And again, Ninth Circuit is so huge, so I don't put any credence in that and don't pay any attention to it. Circuit court is a circuit court, and we take the cases as they come. We get more from you, and I want to thank you for all that business that we get. But good question. Yes, way back here. Yes, sir.
Sir, could you talk a little bit about the sort of discussion and debate process that happens between the justices for those cases?
It's very closely held the way they do it, the way it should be. When a case is argued, they meet shortly afterwards and discuss it and vote either to reverse or affirm. The senior justice in the majority assigns the opinion to a certain justice. They go back and get to work on it. They circulate it to the others. The concurrences and dissents are circulated, and within a fairly short time, look, every case argued between October and April, the decision comes down by the end of June. So it's really a very efficient process up there. But what they do and how they talk and what they say, they keep that to themselves. And their conferences, when they meet to decide which cases to grant and so forth, only the 9 of them are in there. No one's in there, no recording devices, no secretary. The junior justice is the note taker for doing that. But closely held, and you don't hear about leaks, do you, or coming out of the court. Just doesn't happen. I have to tell you this story. A number of years ago, I had a Bulgarian judge over to visit. And it was in the early 90s, and they hadn't seen the sunshine of democracy for a long time in some of those countries. And his English was pretty good, a lot better than my Bulgarian, I might add. But he wanted to talk, and he was older than I am, and he wanted to talk about court administration. How do you administer a court? Because you're living under communism, you don't need an administrator. Why have one? Just do what the party says. But he was interested in this, and he said to me like this, he said, "What do you do about security of your opinions before they are released. And I said, well, security? We have absolute security, total. The opinions are printed right here, 2 doors down from me, inside, locked up. Nobody gets in there. I mean, total security. And I said, in my time here, 10 years or whatever it was, I've never heard, there hasn't been one leak of an opinion. He said, leak? I said, right, nobody's ever leaked an opinion. Leaked an opinion. I could tell we weren't hitting anything here. And I said, leaked. He looked at me finally, he said, I said, that's lick. The poor fellow was thinking of a bunch of law clerks standing around. So we just don't have it. The people that work at the Supreme Court are just absolutely amazing. They're highly qualified, highly trained. They're great Americans. They see their duty as a constitutional duty. I'm talking about the people that reproduce documents and make distribution up to the justices. They're there not to draw a paycheck. They're there because it's a mission. I really mean that. You can be very proud of the workforce up there. They are absolutely fantastic people. I'm just amazed with them all the time. And they come and stay a long time. I mean, we don't have a big turnover, people coming and going. They stay and learn their job. They learn other jobs. There's a chance for promotions lots of times to move up within the framework. So it's a very, very interesting place in that regard. How about another? Yes, sir.
Could you speak to how many cases the Supreme Court heard when you first became the clerk, and how many they hear now and why?
Yeah. Can I expand that just a little bit and say back in the 1980s, I got there in 1991, the court was hearing maybe 120, 130 cases a year. And there were several reasons they had more. At that time, we had more mandatory appeals. Now remember, a cert petition is discretionary. The court can take it or not. We have some appeals in voting rights cases, redistricting, a few like that, where Congress has passed legislation that says you try your case, usually in a 3-judge district court, you then appeal directly to the Supreme Court. You bypass the circuit. It's on a fast track, and when you get an appeal, you must do something with it. You either got to affirm it, reverse it, do something. Where cert petitions, you can deny and it's over. So in, I think, 1988-89, Congress repealed a lot of those laws, so we have fewer mandatory appeals. You also had some things happen. Congress deregulated a lot of industries, so we have fewer of those business regulation, airlines cases and things like that. Plus, I think the court, with more and more former judges on the court, are more discerning in selecting which cases to grant. But there's no game plan or anything. But we went from maybe 120 down to maybe 75. At one time at a budget hearing, I was there over on the Hill, and Justice Kennedy was asked by one of the members of Congress, how many cases should you have every year? And Justice Kennedy's had a lot of experience up there, and on the Ninth Circuit as well, as you know. And he said, 100 is absolute maximum. If the people want us to do a good job, thoroughly analyze, write a cogent opinion so it's understandable, properly staffed and so forth, 100 is all we can handle. Now, we haven't reached that for a while, but again, there's no game plan on that. And I don't see any big change in that either.
Why don't we do one more question?
One more, yes. Come on, some student, some brave 1L. Oh, here it is.
I'm not a 1L. No, I was going to ask, you said that at the beginning you mentioned that oral arguments are great theater, and I'm wondering if you ever think that they're going to make that theater available to the general public via, live streaming or something like that.
He's asking about television in the courtroom. I have no idea. And that's really up to the court. It's something that you can make a case one way, make a case the other way, but come on up and see one. I'll put you on the front row. That is the last one. Let me just say, for all of you, you've been so kind, and to Jeannie and me out here, it's just wonderful to come out to really, it's good to get away from Washington. It's like Fred Thompson said, boy, the reality and sincerity up there. But out here, I see great Americans and great people and great friends. So on behalf of Jeannie, myself, Dean, we thank all of you and your colleagues out here for just showing us a wonderful time, and you've got a great law school. I hope you students know just how fortunate you are to have a great school. And it's not just the building. The building's just a bunch of bricks and mortar. But the people, your teachers and staff, small classes, you've really got it made out here. So I expect to see you up arguing cases in front of me in a few years. Thanks.
Thank you all for coming, for your wonderful questions, and to General Suter for the educational and also entertaining remarks. Thank you all, and I hope to see you all at the next Browning lecture. Good. Oh, yeah, yeah.
One more thing before you go. We just want to, on behalf of the law review, we'd like to thank General Suter and all of you for being here today. And to show our gratitude, we got the General and his wife Jeannie Monty Dolak print, who's a famous Montana artist, so that you can take a piece of Montana back home with you to DC. So
Thank you very much. Thank you.
We'll ship it.
Okay, thank you. Thank you very much. Thank you, guys. Thanks. Thank you very, very much, guys.